appeal in the matter of Infrastructure Services Luxembourg Sarl and another, and the Kingdom of Spain, and appeal in the matter of Border Timbers Ltd and another, and the Republic of Zimbabwe.
Just as a point of information, Mr. Green, I raised with Mr. Justice Trower, who runs the CPRC subcommittee for the Rolls Building, the fascinating point about CPR 6221 and the reference to 74.9,
yes.
Which should be 3 and it's 2. And he looked at it and said, "You're absolutely right. What has happened, surprise, 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 is what was originally A1 became 1.
Exactly.
And then it was removed completely by some Brexit regulation, and nobody bothered to change the numbering. So,
very grateful.
So they will do something within the CPRC to sort that out.
I'm very grateful.
That very important point.
Well, I'm very grateful. My Lords, before I sort of just press on, can I pick up a few points I sort of made vague promises on yesterday? One of them was to my Lord Justice Newey about the European Convention implementation. There are various comments about it, but the best one is in Svenska in the Court of Appeal at paragraph 122, which we find, if the court wants to turn to it just for a second, it's in volume 2, tab 28, beginning at 973. So it's volume 2, tab 28, towards the back, at 973. And that's the beginning of para 122 at the foot of 973. And the passage the court wants is over the page, at page 974. We hope we do not appear disrespectful. And then 3 lines down on the right-hand side, the State Immunity Act 1978, which is the legislation with which we are concerned in this case, was enacted to give effect to the European Convention, but it departed from the Convention in certain respects, particularly in Section 9. We have the benefit of access to the text of the Convention parliamentary materials. So it's absolutely correct, and we get it also in NML, and there's another reference, but it's absolutely right that it had in mind us being able to be signatories to the convention, but it didn't precisely map it. I just thought I might be helpful to give
Thank you very much.
A couple of other quick follow-up points as well, if I may. One of them was I made the reference to Lord Sumption's speech and the precise reference about the nature of sovereign immunity and the drafting point. It was in Ben Carbuche, as I suggested, but I just take court to it briefly, if I may. It's quite a helpful general passage on sovereign immunity.
Yeah.
It's in volume 3, my lords, at tab 41.
Yeah.
So tab 41 again towards the back.
Yeah.
And it's on 1553. And this is obviously quite a well-known section about sovereign immunity, beginning at paragraph 37. Mm-hmm. It's quite extensive, but the paragraph 38, well, perhaps at 37 starting, the fundamental difference between the parties to this appeal concerns the starting point. On the footing customary international law must require the United Kingdom to treat Libya and Sudan as immune. Secretary of State submits that it does. This is because in his submission, state immunity is absolute unless the case is brought within an internationally recognised exception to it. Pausing there, if I can describe that as a sort of brittle approach. This submission, if it's correct, would considerably broaden the scope of state immunity in customary international law by extending it to any group of claimants about whom there was diversity of state practice. In my view, it's not correct. The rule of customary international law is that the state is entitled to immunity only in respect of acts done in the exercise of sovereign immunity, sovereign authority. That Ure and Perry point. And then 38, it's true that the State Immunity Act 1978 adopts the drafting technique of stating a presumptive immunity subject to exceptions. And then he looks at that, and then 4 lines up from the bottom in the middle, the words "as applied," if the court can see those. As applied to international law, the submission is lent a certain superficial plausibility by the fact that the UN Convention has adopted the same drafting technique. And then if we go across to and he mentions Jones and other cases, and then 39 on page 1554 at the top, just above the top hole punch. Sorry. I do not regard these considerations as decisive for the present issue. No one doubts that as a matter of domestic law, Part 1 of the State Immunity Act is a complete code, which we touched on yesterday. The case does not fall with one of the exceptions, the state is immune. The present question is whether the immunity is thus conferred as wider than customary international law. And he says, in the first place, it's necessary, a couple of lines down, necessary by letter C, to read the grant of immunity in Article 5 of the UN Convention, together with the exceptions that follow, as an organic whole. The exceptions are so fundamental in their character, so consistent in their objective, and so broad in their effect as to amount in reality to a qualification of the principle of immunity itself, rather than a mere collection of special exceptions. Secondly, it's important when doing this to distinguish between a drafting technique and a principle of law. Travaux showed that the point was highly contentious, and so forth. And then there are useful, I'm not going to take the court to these passages extensively. So that's the point on the drafting technique, which is of course mirrored in the State Immunity Act itself. And I'll return to that in a second, but just while we're here, can I just invite the court to note there is useful discussion of, over the page on 155, in the section, it actually goes from 155 all the way through to 1562. But if we see it 1555, letter F, just above letter F, before the age of state trading organisations, there are few occasions for testing limits of state immunity. States rarely did act in peacetime within the territory of other states other than conduct diplomatic relations, and that was subject to older immunity law. Leaving aside the rather special case of the immunity of personal sovereigns visiting the foreign state, the only other acts which sovereign performed in the territory of another state involved presence of state owned ships, etc. And what Lord Sumption does is that he traces the development of the law through, and if we look at 1556 at letter C, just by the top hole punch, halfway down that paragraph, but it will be seen even in that context, at its origins, the immunity was not conceived to be absolute. It was assumed to extend only to the property employed for public or government purposes. So he traces through the historical genesis of what becomes the qualification in section 13 of the SIA. And my lords, I only mention that point in passing because I think it may be an answer on the section 2 drafting point, which is a domestic judgment would always be subject to state immunity against execution on sovereign assets at common law, and the 66 Act didn't disturb that. So I think that, I totally take the point that 66 Act drafting could have been more overt about it, but I think the common law principle of immunity from execution against sovereign assets is apt to deal with the point in its entirety, particularly when read with the concept of pecuniary obligations fed in through the convention. So I think that may be an easy answer. The reason I mentioned it yesterday, mentioned the initial point about the drafting technique to the court yesterday, was because of our friend Ground One, and viewed through the prism of the structure of the SIA being as a result of a drafting technique rather than substantive law, it does at least offer a little bit of flexibility in statutory construction. And my Lord Lord Justice Phillips put to me yesterday the two ways in which that might find expression in the judgment of the court, and I readily recognise it may be quite a subtle difference. Maybe it's, in terms of result, it's obviously a distinction without a difference. But there are some commendable reasons for thinking that ground one actually is analysis one that your Lordship put to me, it is actually a simpler and cleaner analysis, in the sense that the 66 Act did the work of changing the common law to the extent necessary. And then the SIA announced itself as a complete code because it was designed absolutely not to interfere with what had already been done in the 66 Act. If that's right, we would say that maybe we win on both ground one and ground two. But there may, or there are alternatives. But in result, it doesn't, we respectfully suggest, matter.
No.
So that was the point on Benkarbush, which I adverted to yesterday. Well, I was just picking up where summary of the two short points I wanted to make from yesterday. One was Benkarbush at the end of the passage I've just given you also restates the par and parem proposition, which I relied on yesterday about sovereign states agreeing between themselves. And the short point is that because acts Ure imperii were immune on any view, that's why the convention was necessary, and because, as indeed the sovereign states themselves submit, the common law itself didn't admit in itself didn't admit a waiver by treaty alone. That's why the 1966 Act was necessary, and that's the answer on those two short points. There's one point on NML, just to pick up if I may, which is found in Bundle 3. In tab 33 at the beginning of Bundle 3 in NML.
Yeah.
And it's page 1108. Sorry, can I take you to page 1129 first, if I may? 1129.
Yes.
This was the section my learned friend referred the court to, paragraph 121 at the foot of the page. I just wanted to highlight to the court the word prior contractual submission to the jurisdiction being ineffective, as what was thought then. And then there's, of course, a helpful review of the cases of Sultan of Johor and so forth, which, in case it's helpful to have the bundle references alongside them on that page, are AB1 tab 6 for Johor, AB1 tab 7 for Duff Development, and AB1 tab 9 for Kahan. But then we get the point I wish to make on this page, paragraph 125, which is only a small point, and I don't think it's really contestable, but it does support our submission in relation to the effect of the 1966 Act, which is that Lord Collins points out, just between F and G, that Kahan had overlooked the fact that submission in the face of court was not the only form of valid submission since the introduction in 1920 of Order 11, Rule 2A. And I only mention it, my lords, just to show that even by a rule of court, there had been intrusions into sovereign immunity from 1920 onwards. So the idea that the 1966 Act had the effect for which we contend is hardly a surprise. Primary legislation is rather more forceful than just a rule change, with the greatest respect, of course, to the rules. So that's that point. My Lords, on the authorities, I'm afraid this is, for us, this is a target-rich environment, and I've only got so much time, so there's an exercise in shot selection. So if I may, I just commend to the court, my learned friend, Mr. Harris's analysis, if one gets into the question of whether it's expressed and whether it's implied, and we look at the High Court of Australia's sensible question of what's expressed in the words, and so they don't need to use a particular word and so forth, which my learned friend, Mr. Harris, has set out extremely clearly in his skeleton argument.
Yes.
So I'm just going to rely on that, if I may. That brings me...
Just to be clear, in the context of section 2 or otherwise, because the express implied point I thought was particularly significant in relation to section 2.
Yes.
Yeah.
Yes.
Yeah.
I mean, in fact, learned
We
friend...
need to have for a submission to the jurisdiction.
Yes. Yeah, my learned friend's done a very good analysis of 2 and 9. If I can adopt his industry and elegance at the same time, that would be very helpful. My Lords, that brings me back to where we left off yesterday, which was Micula,
Yes.
which we refined with anticipation in bundle 4.
Yes.
There is rather, it's obviously, we have to bear in mind there's a head-on clash between the EU and the UK in relation to Micula, which is at bundle 4, tab 45. And I'm going to anticipate a question I think may be coming from my Lord Justice Newey about the perfect storm that may be said to have arisen as a result of the CJU judgment and its binding effect during the transition period. That was rather a poor pun, because my Lord gave a leading judgment in the perfect case, which dealt specifically with the effect of the Withdrawal Act and the Withdrawal Agreement. I'll deal with that quite briefly. There's a high-level answer, and then there's rather a more difficult answer. And the difficult answer is very difficult, and the high-level answer is very easy. I'm going to invite the court to anticipate which one I'm going to urge upon you, but I've probably got to, in fairness to the court at least, to deal with both.
Very well.
The decision in Micula rested on, there are 3 elements to it. There's the element about what the ICSID Convention means and the 66 Act achieves. That is untouched by the CJEU judgment. And we rely on that because we're no longer in the EU, and so that, we say, it explains what the Convention and the 66 Act did. Sovereign states are absolutely right to say it was a different case, it was about a stay and so forth. And equally, the learned judge, Mr. Justice Fraser, as he then was absolutely right to say what they don't face up to is the ratio of it is powerfully supports the learned judge's decision.
Yeah.
So that's the answer on part 1. Part 2 was the Supreme Court's own careful, word I'll return to, analysis of the multilateral nature of the ICSID Convention, to which the United Kingdom is a party and to which the EU is not a party. And the court reached the view, and it does so particularly between paragraphs 104 and 108, which we find at page 1698 to 1700. It reaches the view that these are not simply bilateral, a bundle of bilateral obligations. And I will in due course be submitting that the EU's attempt to characterise multilateral treaties as no more than a bundle of bilateral obligations is overreach and unjustified on the law by any conventional means of treaty interpretation and by the means of treaty interpretation adopted by the Supreme Court in Micula. So that's point 2. And that does clash with the CJU decision, which astonishingly criticises the superficiality of the Supreme Court's analysis of international obligations undertaken by the United Kingdom prior to being members of the European Community, which were undertaken and knowingly undertaken by the United Kingdom, having understood what they were, and whose ultimate meaning is to be determined by the International Court of Justice under the ICSID Treaty. The CJEU decision makes no reference to the Vienna Convention on the Law of Treaties, makes no reference to the fact that the ultimate arbiter of their meaning is the ICJ, and holds that in fact the CJEU in this context is the only ultimate arbiter of the extent and nature of international obligations undertaken by this country with other countries, not the EU, before we joined the European Community. And this is one of the reasons for which we say the EU's, CJEU in particular's, lack of comity in relation to this general area has been extreme. It's also extreme because the Supreme Court, in its reasoning, carefully considered where there was a risk of conflict and foreshadowed that that would be extremely unlikely because of the EU's duty of sincere cooperation with the United Kingdom as a member state. And that's why the EU would not reach a contrary view. And notwithstanding that, the CJEU did reach a contrary view that does not accord the decision, careful and thorough decision of the Supreme Court of the United Kingdom, the respect which international comity might normally be expected to attempt. So it's not easy, but the short point, I think, and we have got, can I just hand up a very slim...
Consider with 3 elements, you've given us 2.
So sorry, one is, one is, you're absolutely right, my lord. The first one is ICSID and 96 Act, untouched
by the court.
The second one is the meaning of our international treaty obligations, which...
Carefully considered by the Supreme Court.
Yes. On that one, the short point is there is a 0% chance of the Supreme Court, now that supremacy of EU law doesn't apply, reaching a different conclusion on the nature and extent of our treaty obligations. And the second point on that is it was in fact wholly without the CJEU's competence because it was not a question of EU law. And the reason that there's even more extreme lack of comity is because the Supreme Court very carefully analysed all the cases which show that it is a matter for the national court to identify those obligations. And that is what the court had consistently held prior to the Supreme Court's judgment. And we can see the foundation for that. If I can just show the court quickly, the foundation for that is in Costa and ENEL, which is in, just find it there, it's in tab 5. Oh, I'm going to just pause because your Lordship asked me a question, I haven't actually answered it. What was the third bit? The third bit was Article 351 and the proper interpretation of Article 351, which I'll show the court originally accepted the conventions that were entered into on its face. That language was finessed once down to the obligations arising under the conventions, not the conventions themselves, by the CJEU. And then it's been finessed again down to break up multilateral treaties into bundles of bilateral obligations. So that's the course that journey has taken on 351. It was a course that was not accepted by the Supreme Court. And it is the point on which some difficulty arises, because the argument which I made before the Supreme Court in Micula on the relevant constitutional principles, which the court accepts were correct, was not pursued by the court because they had the argument on Article 351. So the argument I made, and I accept it's relatively extreme, was simply to say that when Parliament enacted the 1972 Act, it had before it a treaty which said, in perfectly clear terms, this won't affect prior international obligations entered into before the treaty. And that's what Parliament enacted. And so it's a delineating provision of the conferral of competence, which is a fundamental principle of the relationship between member states and the EU. And I think it was my only good point in the Gina Miller case, was that it was Parliament's competence to confer, Parliament's competence to exercise legislation, Parliament's competence to confer on the EU, and therefore Parliament's competence to take back on the Article 50 point. And that's derived from the analysis originally foundationally in Costa and ENEL. And the argument of the Supreme Court was, if Article 351 does not do the work that Parliament thought it did, then the 1972 Act is limited, and we never, as a matter of domestic law, agreed to the CJEU unilaterally changing what Article 351 meant. So that's a head-on clash with EU law. It's a pretty serious submission to make. The Supreme Court didn't doubt the principles, which are set out on page 1692, and I'll show the court those just briefly, if I may.
Do you want to look at those now?
If we may. I'm not going to spend a huge amount of time on it, because I think...
I've got a bit confused now, because you're looking at 2, and you referred us to Costa. Now we're on to 3, are we?
Yeah, my lord, yes, they overlap, actually. So...
Are we? We're not looking at Costa then, or we're going to go back to...
I'm definitely going to Costa in a second, because I thought it might be helpful to introduce the relevance of the conferral, because you get from Costa, you get both conferral on point 2, and you get the division of responsibility between member states and the EU for Article 351 on point 3. So, my lord, I'm sorry to have ducked between the two. That was not a helpful way to present it. I'll try and clarify.
Putting it shortly, if I may.
Yes.
The submission you made in Micula, which was accepted by the Supreme Court, was that what is now Article 351 had been, I forgot what number it was now, it doesn't matter.
It starts, exactly.
In the 1957 treaty, was what was it was in relation to that provision and how it was interpreted that Parliament enacted the 1972 Act. And to the extent that the CJEU has now said, well, it actually means something more extensive.
Doesn't work.
They've overreached themselves,
Exactly.
and it was never binding
Yes.
on the UK. I mean,
Yes.
is that
Exactly.
Put it?
Yes, my lord, yes. And just to,
That's what's caused the unholy battle royal between
well, I think,
the UK and the EU. Because
I'm sorry if I started the fight, but I think it was going to happen anyway because of the investor treaty thing. I mean, it's embarrassing for me.
Well, I mean, there are 2 points, aren't there? I mean,
Yeah.
There's that point, if you like, the 351 point, and there's also the fact they clearly don't like investor treaties, even though they actually approved the ECT.
Yeah, I mean, I'm going to show the court the position on the ECT. It's far worse than the court may think. I mean, it's bad. But just dealing with this part, I just want to identify a point against myself and explain why it doesn't matter on this point. Your Lordship summarised it correctly, but it's right to just identify quickly that there's a point within the argument that was against me at the bottom of paragraph 89, just above H. in these circumstances, if the court sees that,
Yes.
in these circumstances, there's no sound basis for concluding that the effect of Section 2.1 of the ECA was impliedly excluded so far as the 1966 Act is concerned. And this is for two reasons. One is that just above that, that's not a statute of fundamental constitutional importance, is one reason. And number two is because the 1972 Act has already got Article 351, which on the Supreme Court's analysis works correctly. And my lords, it's just it may be helpful for the court to understand that those are two ways the potential 1972 point can come up in the past cases which are referred to by the Supreme Court. One way, the constitutional way, is the CJU makes a decision and it conflicts, for example, with the Bill of Rights. So the decision they make is, as a matter of subject matter, within their competence, but the decision they make conflicts with the fundamental constitutional principle. That's the constitutional objection, if I can call it that, which was in HS2.
Yes.
Identified by Supreme Court in HS2. There's a different category. Now, I don't avail myself of that, although I do say actually that the United Kingdom's ability to interpret its own treaty obligations is a fundamental constitutional principle, and now I have got a good point, even if I didn't in Micula. So that's that point.
When you say you've got a good point, you mean a good point on the ICSID treaty?
On the ICSID treaty, yes, because
and the ECT treaty.
the question now in issue is not a domestic piece of legislation enacting the ICSID Convention. The question, if it arises at all, is whether the United Kingdom Supreme Court is competent to interpret our own prior existing treaty obligations constitutionally, or whether we confer that on the EU. And the answer to that is that's important, and it's not what happened. So I do say, actually, although I didn't have that in Micula because of the way it arose, I do have it now in the light of the CJEU decision. So if push came to shove, my lords, that I would submit that that's the position on the 1972 Act.
Mm-hmm.
But the main way it arises is in relation to the delineating provisions. So the conferral of competence, as we'll see in Costa and ENEL, conferred on the community certain exclusive competences, reserved to the member states other competencies, and allowed some joint competencies. And it's in relation to those delineating provisions that the 1972 Act argument remains a good one. And indeed, the Withdrawal Act refers to the law as derived from the 1972 Act. So the Withdrawal Act can't go any further and wouldn't be construed to go any further than the 1972 Act itself. So if push came to shove, that is what I would say. But the simpler, so this is the difficult answer, right?
Well, this is the point.
The difficult point.
You addressed in Micula.
Exactly.
Appear to have accepted.
Exactly.
That it wasn't for the CJEU to put the United Kingdom in breach of pre-accession treaty obligations, of which the ICSID treaty obligations clearly are.
Exactly. And that's basically...
I think the ECT ones wouldn't be because they were post...
Absolutely correct. Absolutely correct. So that's the argument in relation to that. On 351, can I show the court Costa and ENEL, which is what I promised to take you to.
tab 5.
And I'm sorry for slightly bouncing between points 2 and 3 for a minute there. They sort of overlap slightly. So we find Costa in tab 5.
Volume.
Sorry, volume 5. Apologies. And at where are we?
67.
Tab 67, exactly. Sorry. Most correct. And the key page, well, pages really are start on 2570, grounds of the judgment. So this is on Article 177. So this is the preliminary reference procedure, which is important because it's the procedure that is ultimately the one that the United Kingdom, according to the CJEU, failed to use in Nicola when it should have done according to the CJEU. And it's just important for the court, this court, to understand how totally reasonable the Supreme Court's appreciation of its duties on the separation of functions was. And the 2571 top hole punch, just below the top hole punch, since, however, Article 177 is based on a clear separation of functions between national courts and the Court of Justice, it cannot empower the latter either to investigate the facts of the case or to criticise the grounds and purpose of the request for interpretation. Then it, bottom hole punch, it makes the point of, not unlike ordinary treaties, it's got its own legal system. We'll come back to that later. And then immediately below that, by creating a community of unlimited duration, having its own institutions, its own personality, its own legal capacity, and capacity of representation on the international plane, more particularly real powers stem from a limitation of sovereignty or a transfer of powers from the states to the community. The member states have limited their sovereign rights, albeit within limited fields, and have thus created a body of law which binds both their nationals and themselves. So that's the sort of foundational example of the separation of the tasks of the national courts and the CJEU, as it became, which then found expression in the cases referred to by the Supreme Court in Mikula, such as Levy, where the Supreme Court identified that it's for the national court to identify the existence of any prior international obligations, and against that background to reach its decision on whether or not there is a conflict under Article 351. So, in fact, that doesn't, Article 351 doesn't impact on this appeal. I thought it right to set out why the Supreme Court might feel somewhat aggrieved at the treatment, its very careful treatment and analysis of the multilateral nature of the ICSID Convention, which we rely on, as untouched, because it's quintessentially a matter of international law to be determined by this country as a member of the ICSID Convention, and it's not uniquely to be determined by the CJEU on the basis of their own past, their case law that predated the decision in Mikula, which they then flipped in an imaginative way in order to be able to overturn the Mikula decision.
You said a moment ago that it doesn't arise on this appeal.
351 doesn't.
Is that because
We're no longer in
dealing with
the
the ECT, or is it because we're no longer members of the European Union?
Both.
Yeah.
Because
Since what's said against you, I think, or one of the things that's said against you is, well, whatever was preserved by what's now 351 doesn't actually matter, because what we're dealing with is a treaty which was passed post-accession.
exactly, and that's the treaty I'm going to take the court to now, if I may, because it's pretty striking what actually happened.
Very well.
If I may. So
Do we need Costa anymore?
we don't need Costa, and that can go away. I'm very grateful.
So what do we need?
So we now need probably the most popular bundle for this section, which is bundle 7,
Right.
which is useful because it's got both the ECT in it at 106, and it's also got the VCLT in it
Yeah.
at tab 101, I think it is.
Yeah.
So can I begin in tab 106 with the ECT? Because it's quite important to look at exactly what happened.
Tab 106, yes.
And I don't know whether any members of the court managed to get to Sir Alan Dashwood's second article at tab 147 at all. But he gives a coruscating criticism of Comstroy in characteristically charming language, but it is pretty brutal, and particularly with regard to the ECT. And in doing so, he also refers to the opinion of the correct opinion of the Advocate General Watherley, before the Acmair decision. So he was the AG giving the opinion in Acmair, saying, well, I don't understand the problem. And gives good reasons, which I'll show the court.
Yeah.
And then the court does the opposite to the AG's opinion in Acmair. And so Sir Alan traces that through in quite a helpful way. But if we can start with the Energy Charter Treaty itself.
Can I just understand
Sorry.
a moment? Where in the overall scheme of things are we now?
So we're now on section 9. Is it invalidated by reason of the ECT being a bundle of individual obligations, not a multilateral treaty that everyone else thinks it is, such that EU law overrides international law, and
So
there's
you've said
no...
all that you're going to say about section 2.
My lord, yes, subject to a couple of points at the end to pull it together. So if there's any particular ones I can help you with on section 2. Is it helpful to deal with those now?
Can I just ask, I don't want to stop you,
Not at all.
but can I ask you one thing which slightly
Yeah.
troubled me overnight? The argument which was advanced in relation to section 9
Yes.
is, as I understand it, because of EU law primacy, there is this, and this court must accept that there is no valid arbitration agreement,
Yes.
and therefore no valid award. My question is, if that is right, why is that limited to an Article 9 problem? Why isn't it a problem for the whole treaty match?
Well, I agree. But Milan, I think Spain's position tries to finesse it in a way which I think the court challenged. They say they're not challenging the award. They're just challenging the validity of their city only seeking to set aside the registration of the award here. But I mean, that's a distinction without a difference.
Mr. Ballack said more than once yesterday afternoon, well, of course, we're not stopping them from seeking to enforce the award anywhere else in the world, like Australia, for example.
Yes.
Which isn't a member of the EU. But what you can't do is...
Understood. But I mean, that if the argument's right...
The logic of that, the logic is... I mean, at the time, I wondered whether that attempt to, as it were, finesse the point, as you put it,
Yes.
really worked.
Yes.
Because if the truth is that the EU law is it has primacy as a matter of international
Exactly.
law, why isn't that binding on
It goes everywhere.
the Australian court and the United States court and any other court?
Well, that's the point.
I mean, either it's binding, because we're no longer members of the European Union.
No, exactly.
So if it's binding on us,
Yes.
why isn't it binding on everybody else?
Yes. I mean, it's not an analysis which we would invite the court to accept for reasons I hope are obvious. But your lordship's question is right. I mean, the way it's put in terms of invalid consent under section 9 is at least capable on one analysis of affecting the section 2 argument. The difference, though, is if
Well, it affects, doesn't it? It affects section 1 of the 1966 Act.
well, they would have to say that. Yes.
And there is no award to enforce.
Yes, I think what they, if I understood it correctly, and it may be me if I didn't, but if I understood it correctly, I think the argument is it can't work under section 9 because there isn't a valid agreement to arbitrate, not that it doesn't work under section 2, if I've understood it correctly.
Yeah, I think that's right.
But if there's no agreement to arbitrate, there's no award.
Well, that's the problem. That's the problem with trying to distinguish the two. I mean, I can see that you could, the learned friend has, as I understand it, confined his argument that the impact of the invalid agreement to arbitrate is on Section 9. But your Lordship's right to raise the difficulty that on one view, if you follow it through to a reasoned conclusion, if it's said to invalidate the award in breach of the express terms of the ICSID Convention, if that's right, then in one sense there isn't an award at all as a matter of international law, because there isn't a valid agreement to arbitrate, and everything that the ICSID Tribunal's done has been undone for all purposes and for all times. I mean, it's a giant submission. But my Lord, I hadn't actually thought that through, because the way it was argued was really, I thought, confined to Section 9. I think the Lordship's right. You know, on one analysis, it could feed through to Section 2. I think there is another analysis.
I don't really. So the other. So that's going to say, what is the other
Yeah.
analysis?
Well, I'm formulating it on the hoof slightly, but I think that the answer might be said to be that the obligations undertaken under the ICSID Convention are such that they are freestanding obligations, that the contracting states are agreeing to submit or confer, there's probably no difference, jurisdiction to the other contracting states to enforce any award which is authentic and has been found to be authentic on the basis of what the tribunal has decided is a valid arbitration agreement of which it is its own judge under Article 41. And so that's a freestanding submission under the convention, which is not actually analytically dependent at all upon the underlying validity of the agreement to arbitrate. So if there would be, as a matter of English law, an invalid agreement to arbitrate, which is what the learned friend contends, or international law he contends, if the tribunal has itself found that it does have jurisdiction on the basis of a valid agreement to arbitrate, it's an ICSID tribunal, totally different with New York Convention. If the tribunal has found that under Article 41, and the contracting states of the convention have said it's for the tribunal to decide, and if you decide against us, you make an award and it's authentic, everyone can enforce it. And that, I think, my Lord, might be a complete answer. The freestanding nature of the ICSID Convention and the obligations undertaken, which are well known and well established to be a self-contained system, does not admit the possibility of undoing any submission in the ICSID Convention itself by reference to a matter affecting the validity of the underlying arbitration clause. So that is the second analysis. And I think it's a respectable one.
Well, it's an analysis that says that Article 41 makes it clear that once the tribunal has ruled, it has jurisdiction.
That's it.
That's it.
Yeah.
Court. Unlike in a New York Convention context,
Almost
in
the
the
opposite.
context of the ICSID Convention, there's no, the only circumstance in which the court could, as it were, intervene would be possibly fraud.
Yes.
And an unspecified further, but almost certainly extremely narrow.
But no one's identified.
Nobody's actually identified.
Exactly. And the Supreme Court wasn't quite prepared to rule out completely.
No.
But I mean, I think that would be, in fact, the conventional approach to the answer on Section 2, because it's well understood to be a completely closed system, and it's definitive. The award is definitive of everything decided, including the decision on jurisdiction of the arbitral tribunal.
The difficulty I have with all this is and it maybe it's for Mr. Ballot to explain this and reply rather than for you to try and grapple with it. But in a way, it does affect you, though, because if the argument is right, it also affects grounds 1 and 2.
Yes. Which I hadn't anticipated it did, but now your Lordship's raised it. I think I can see logically why that's one analysis that it could, but I think the answer to it is the convention
can I just say what
Yes.
where I'm struggling with it?
Yes.
As I understand the argument of Section 9, it is, well, whatever ICSID says, when you come to apply Section 9, this court has to accept that as a matter of international law, EU primacy, there is no valid arbitration agreement.
Yes.
That's the argument of Section 9.
Yes.
I don't understand why we don't also have to accept that when applying Section 1 of the 1966 Act.
Well, but because Section 1 of the domestic legislation just tells the court what it has to do when presented with an authentic award. It doesn't give you any, all the bits that are missing from the 96 Act and New York Convention are very striking. They're exactly the points that are covered by Articles 50 to 52 on an annulment application. Spain argued this, we can see in this case. You've got the analysis of Lord Collins's tribunal in Cavallo, which I mentioned yesterday and is on the foot of the references sheet. And you've got the analysis of the Spain tribunal rejecting it in this very case, the argument being made on the ECT. So, my lords, I'm not saying it out loud each time, but obviously we say they're completely wrong on the international law consequences of what's been said within the EU. But my Lord Justice Phillips' question is premised, if they're right about that, would it have the knock-on effect on grounds 1 and 2? And in my respectful submission, it can't. And it is, that's why the question of whether our friend ground 1 matters or not might become quite important, because the straightforward operation of the 1966 Act should not really be a prisoner to any qualification by the 1978 Act.
But the point, I mean, the way in which the matter was argued yesterday,
Yes.
as I understood it, the reason why there's a submission to jurisdiction within Section 2 of the SIA
Yes.
is because there is a prior written agreement in the form of the ICSID Convention,
Exactly.
to which this country is
Yes.
a party.
So that's the
It
submission.
confers jurisdiction on the English courts
Exactly.
in these circumstances,
Yes.
where there's been an ICSID award,
Yes.
which can't be challenged for all the
Exactly.
reasons we debated.
Yeah. And it's
And in a sense, it's a self-contained point,
exactly.
and the sort of the 351 European Court overreach point whatever it overreaches to, it doesn't overreach to that.
No. It's completely
That's your
self-contained point. It's my lord, in a sense, your lordship's point to my own friend yesterday. We're looking at Article 54. They're agreeing, aren't they? I mean, that's what they are doing in the ICSID Convention, entirely on its own, on the basis that under Article 41, jurisdiction will be determined by the tribunal itself. This is a totally closed system. And it's been referred to that by, I think, the Supreme Court in particular. I think they say that and in lots of other decisions. So I think that is the answer on Section 2 and actually ground 1.
Can I jump
Yes,
to a different aspect from
Yes.
that, just so I understand where you're heading?
yes,
Is it on your case right that the member states who are relevant to these proceedings, Spain and the countries from which your clients come, are bound as a matter of international law by virtue of the EU treaty and the decisions of the CJEU to proceed on the basis that there is no arbitration agreement,
no, it's not right.
even as a matter of international law as between themselves?
Well, as a matter of EU law, inter se, that they may be. But as a matter of international law, judged from the perspective of the tribunal and this court, absolutely wrong. And that's, of course, what Cavallo analyses. And I can show the court why it absolutely does not work.
I mean, it may not work, but I don't entirely understand why, if you look at their international law obligations, they are not to be found in EU obligations that they have undertaken and have been interpreted in accordance with the
Well-
obligations by the CJEU.
Yeah, I'm sort of slightly running ahead, but I don't mind at all.
Yeah.
My lord, there are massive problems.
I think you better not run ahead. You
Well,
better
well,
wait till you
well,
get.
I can give you a sort of helpful,
Yeah.
you know, signposts because it.
Why don't you give us a signpost and then go back to
Yeah.
dealing with ECT, which is where he wants
Exactly.
to go.
But the short point is the ECT was agreed to by the EU as a contracting party. It has international obligations, pacta sunt servanda, not just to agree but to perform the treaty in good faith, which is in flagrant breach of, by the way. So that's the starting point. It's particularly bad because the EU tried to negotiate a disconnection clause on Article 26 during the negotiations of the ECT, and everybody said, what on earth are you talking about? Because there are 54 signatories to the ECT. And this is a point made by Professor Dashwood in his article. And everybody said, what on earth are you talking about? Absolutely not. You have to have the ISDS provisions for dispute settlement and the arbitration clause in Article 26. And there is a specific reservation made of absolutely minute proportions made by the EU in relation to Article 26, which is just the permissive reservation, which I'll show you in a minute, the permissive reservation that people can still go to the CJEU if they want to. That's all. There's absolutely no disconnection clause at all. They tried to negotiate it, they didn't get it, and then many years later they suddenly announced, oh, by the way, we did get it after all. Well, I mean, that's on the international law plane, that doesn't even pass summary judgment. It's hopeless. And with the greatest respect to the elegance and persuasiveness with which the Article 5 point was put about the internal VCLT argument, and that's totally hopeless as well. All the VCLT is saying in Article 5 is it just says, if you've got a Treaty of Rome, for your own internal purposes, you interpret that inter se in the way that the Treaty of Rome says. But I mean, that's what it does in relation to all other treaties as well. The governing treaty is the primary source of interpretation, and the VCLT carves out specifically in every provision almost that the governing underlying treaty is the first port of call. And that will become important when I develop the submissions on whether the unilateral declarations of various different member states that we looked at yesterday make any difference at all, because they completely fail to satisfy the requirements for the modification or disapplication of the ECT that are found in the ECT.
Right.
And they also fail, by the way, as backup, to satisfy the requirements for modifying a treaty in the VCLT, which I'll also show the court. So I mean, it's absolutely appalling what's happened. I'm sorry to say that, but it is. And I did my stage at DG4, which seemed to be pushing this, so it's not a comfortable submission to make. But it is appalling, and it is astonishing to see the.
Was driven by two things, isn't it? With which, speak for myself, I'm not totally unfamiliar over the years. One is that the European, or the CJEU as it now is, doesn't like arbitration. And the other is that it doesn't like the ICSID stuff because they think it's all state aid.
Yes, I mean.
So it's a sort of
the basis.
meeting of the two.
Yeah,
the two.
exactly. Well, there's one chap at the Commission who's frightfully keen on this, on the state aid point, who's pushing it. I mean, he's quite extraordinary how we've ended up in a fantastically unsatisfactory position. And I mentioned yesterday to the court the point in the Mikula case that arose about the Europe agreement requiring the members, the candidate states for the EU to enter into these bilateral investment treaties. I mean, that's not just a point I made, it's a point made by Advocate General Wathley in the AG's opinion, which I'll show you if I may.
Yeah, okay.
Because that actually didn't make it into the bundle, so I've got a tiny...
Where you were going to show us the ECT?
Yeah. that was probably a better thing to go back to what I was going to try and do. But I hope that gives us a general signpost.
Yeah.
On the international law plane, it is a completely hopeless argument to say that the EU primacy, which is an internal, as Professor Dashwood also points out, is an internal principle of EU law, binding member states, has that effect on the international plane to trump the terms of the very treaty that the tribunals are called to interpret and to apply in making their decisions. I mean, that has never, ever happened. So it's completely hopeless, but it's more hopeless when you look at the actual contents of the treaty for reasons that I'll come to. So we're in tab 106 at 3597. And there's the preamble, and there are two paragraphs that are worth looking at there, recalling that all signatories undertook to pursue the objectives of the European Energy Charter and implement and broaden their cooperation as soon as possible by negotiating in good faith an Energy Charter treaty and protocols, and desiring to place the commitments contained in the Charter on a secure and binding legal basis. Pausing there, this is a recital in the preamble about an undertaking to negotiate this treaty in good faith. And the point that Advocate General Watherley makes is that there was no disconnection clause in the ECT. There's a specific provision, which is later used by Belgium in Opinion 120, which I'll show you, to ask in advance whether a treaty that the EU is going to enter into is in accordance with the treaties. And they didn't use it. And Advocate General Watherley said that's because no one for a moment thought it was in breach of the provisions of EU law. So the premise of the treaty is that it was negotiated in good faith. And what all the international tribunals have said is if that's the case, and you were going to disapply Article 26, it would have required an express statement in the treaty to that effect or an express reservation. And I'll show you there's neither. So, pushing on, if I may, Article 1 on page 3598. It's Article 1, paragraph 2. Contracting party means a state or REIO, which is the EU, which has consented to be bound by this treaty and for which the treaty is in force. So that includes the EU. 3600, 2 pages further on, purpose of the treaty. This treaty establishes a legal framework in order to promote long-term cooperation in the energy field based on complementarities and mutual benefits in accordance with the objectives and principles of the Charter. There are Article 6 on 3601, competition. Each contracting party shall work to alleviate market distortions and barriers to competition and economic activity in the energy sector. Just pausing there, it's right that as soon as you say, if the investor is an intra-EU investor, this goes to my Lord's point yesterday about whether it makes a difference to what difference it makes if the obligations are breached. And the court, I think, was thinking about specific examples of joint investments, joint investors and that sort of thing. A completely different policy point at a high level is a massive distortion in the market, because if EU countries favour EU investors, they know that they can treat them in breach of the fair and equitable treatment standard in the ECT with total impunity. So there is the effect of what is contended would lead to exactly the sort of distortion, a market distortion, which Article 6 was designed, and the treaty as a whole, was designed to avoid.
But it sounds as though the market distortion would be adverse to member states.
But, my lord, that's still, not all member states are very happy about this. They've been forced arm wrestled by the duty of sincere cooperation to go along with what the Commission says. So my learned friend says they speak with one voice. That is quite a finesse. And also parenthetically, when he said the CJEU speaks on behalf of all of the member states, I mean, that's demonstrably wrong in relation to the ECHR opinion of the CJEU, because the court will remember that the EU was encouraged to become a signatory to the European Convention on Human Rights, ducked it, and then all of the member states put in a mandatory provision in the Treaty of Lisbon saying, you shall, and the CJEU went, well, no, unfortunately, autonomy and primacy mean we can't do that, so, sorry. And so we then get the general principles and the Charter internally. So let's just be clear that recently the CJEU has not been the mouthpiece exactly of the member states in the ways suggested. And that example is the most striking example, I think, in the union's history. Anyway, moving forward back to the ECT, you've got the facilitation of transit provisions through states to other states in Article 7. And the no less favourable treatment, 3603, Article 7.3, second line to third line. These are all very important. The ability for energy to come through country B to country C is super important to country C, not just country B. This is a network of obligations which can't be disentangled. And that's how the ECT has been understood. It's not a bundle of pure bilateral obligations, and nor is it fair to say that treating the dispute resolution procedure under Article 26 in that way is bilateral either. I'll come to that. Article 9 is about the importance of open capital markets and encouraging the flow of capital. So that's all about the same sovereign risk objective, which ICSID is about. And then Article 10 in Part 3 is the FET standard and the express wish to promote and protect investments. And it's right, just so the court knows, if the investors in this case do not have recourse under ICSID because of what's happened by the EU, they've got nothing. I mean, it's pretty striking. And the learned friend gave, I think, yesterday, very helpfully, some of the relevant dates. I thought it might be helpful for the court to have just one sheet with the key dates of investment and so forth, and the relevant treaties to hand to put it in context. Because what in fact happened was that support was promised to encourage green energy investments in Spain, because Spain wanted to have a green energy infrastructure. And people raised funds and made enormous investments in the billions. And then on the basis of the promised support that was in the original royal decree, and then once it was all built, the royal decree was pulled. Effectively, the support was taken away. And that breached the fair and equitable treatment standard in the ECT. So you're left with absolutely no remedy, not least because it's as a matter of Spanish law, that's what the law did. And also because the EU is contending that the awards made by ICSID tribunals are unlawful state aid as well, because of the basis of calculation. And that was a point I think I made on the security application in this case in front of your lordship, which is to say, you know, pretty unusually, Spain agreed with the Commission in the investigation of state aid, went, oh yeah, absolutely state aid. Yeah, no, we don't have to pay 120 million to them and the other 25 awards, plus the ones in the pipeline. I mean, normally, states defend the legitimate grant of support that they believe is lawful. So it's an unusual situation in that respect as well. Returning to the convention, if I may, there are a couple of other key points. Probably the most important is obviously Article 26. If I can go there and then come back to Article 16. Article 26 is on page 3618. And it's really important to look at the actual precise terms of Article 26. 26.2, if such disputes cannot be settled according to the provisions of paragraph 1 within a period of 3 months from the date on which each party to the dispute requests amicable settlement, the investor party to the dispute may choose to submit it for resolution to the courts, administrative tribunals, or contracting party, in accordance with any applicable previously agreed dispute settlement procedure, or C, in accordance with the following paragraphs. And then 3A, each contracting party hereby gives its unconditional consent to the submission of a dispute to international arbitration or conciliation in accordance with the provisions of this article. And then the contracting parties listed in 1D do not give such unconditional consent where the investors previously submitted the dispute under paragraph 2A or 2B. And
Are there any countries in one?
yes, and my lords, I'm afraid I do need to give you this little extra bundle just to make that point good. It's also got Advocate General Wathlay's opinion in it.
Yeah, okay.
I hopefully won't need to go to many of the cases there. Because it's fair for me to take the point against me and then show why it doesn't apply, that actually the EU did have the very small revision contemplated in Annex 1D. So the court will see that at tab 11, sorry, yes, just noted it. So tab 11 is the information that any contracting party in 1D has to provide about the extent to which the consent is unconditional in any way. And all it is referring to there is the circumstances in which the Court of Justice, which is 5 paragraphs down between the 2 hole punches, as the judicial institution of the community is competent to examine any question relating to the application and interpretation of constituent treaties and acts adopted thereunder, including international agreements concluded by the communities, which under certain conditions may be invoked before the Court of Justice. Any case before the Court of Justice of the European communities by an investor of another contracting party in application of the forms of actions provided by the constituent treaties of communities falls under Article 26.2a of the Energy Charter Treaty. Given that the community's legal system provides for means of such action, European communities have not given their unconditional consent to the submission of a dispute to international arbitration or conciliation. And the short point is, all we're saying is that any action before the CJEU is an action permitted under 2A, even though the CJEU is not the court of the same contracting party. It's a permissive option. It is not the disconnection clause that they sought in negotiations. So subject to that, it makes no difference to the outcome, but I just thought it was right for the court to see that when they did appear in Annex 1D in 3B1, the qualifications are in relation to subparagraph 2A or 2B above. They're not in relation to 2C. And the international arbitration provisions then follow. And we've got at 26.4, in the event that an investor chooses to submit the dispute for resolution under subparagraph 2C, the investor shall further provide its consent in writing, it's back in the ECT now, for the dispute to be submitted to ICSID, is A1 on page 3618. Bottom of the page, 26.4, little a1 ICSID. And that's the case if the contracting party of the investor and the contracting party to the dispute of both parties of the ICSID convention. And then 6 is important. because 26.6 provides a tribunal established under paragraph 4 shall decide the issues in dispute in accordance with this treaty, which is the ECT, and applicable rules and principles of international law. So the ECT itself specifically provides that the tribunal shall apply the treaty, the ECT, and the applicable rules and principles of international law, not EU law, and there was no disconnection clause which could have that effect. There's, just before I go back to Article 16, there's one at the back which the court needs to see. 3631, Article 46, there were no reservations that were made to this treaty. There was one specific external treaty, the Slavblad treaty, which was had primacy over the provisions of the ETT, and that was very carefully negotiated. So you've got a specific example of another treaty that was very specifically negotiated, which could have had the sort of effect that the EU is now contending for. The EU treaties were not dealt with in that way, and they tried to get a disconnection clause, and it was refused. And when we go back to Article 16 on page 3611, the treaty is pretty clear there too, because it makes express provision for relation to other agreements, where two or more contracting parties have entered into a prior international agreement or enter into a subsequent international agreement whose terms in either case concern the subject matter of Part 3 or 5 of this treaty.
So where are you reading from?
Sorry, top of page 3611, apologies, 3611 in the ECT.
Yeah.
So it's 3611 at the top, and we're looking at Article 16.
Yeah.
It's really important. It's the relation to other agreements provision in the ECT itself. And it's where two or more contracting parties have entered into a prior international agreement or a subsequent one, whose terms in either case concern subject matter of Part 3 or 5. And 5 is obviously dispute resolution procedures. Nothing in Part 3 or 5 of this treaty shall be construed to derogate for any provision of such terms of the other agreement or from any right to dispute resolution with respect thereto under that agreement, and nothing in such terms of the other agreement shall be construed to derogate from any provision in Part 3 or 5 of this treaty, or from any right to dispute resolution with respect thereto under this treaty, where any such provision is more favourable to the investor. So the ECT makes, within its own terms, a totally conclusive provision where there is apparent treaty conflict of the type the learned friend was referring to, that there's no effect if the other arrangements are better for the investor. So there's an immediate point, just on the bare work, before we get into any of the EU arguments and international law arguments, the ECT, Article 16, has total preclusive effect on its own terms to disadvantageous to the investor alternative international agreements having that effect.
Can I just understand how far this goes? So suppose you have a treaty between countries A, B and C,
Yes.
including a provision that if they agree anything different later, it's not to have effect. And then countries A and B agree between themselves something different in a later treaty.
Yes.
What's the consequence as between A and B?
So the consequence between A and B, if, well, the problem is that because this is about investor protection, there are two planes on which the analysis has to be undertaken with care. There is the international law plane for the ICJ, as between A, B and C, in fact, where the compliance with Treaty 1 in entering into Treaty 2 will be litigated and decided. That's a separate issue. But the uniqueness of the ISDS provisions is that, of course, they confer what are effectively private international law rights on the investors. So the whole point, the reason you have Article 16 is to stop the essential protection that's conferred on investors being fiddled around by what a few member states might later agree between themselves.
The answer to my lord's question, if A, B and C are parties to the ECT, and A and B then later into another treaty with the terms of which are less favourable to investors than this treaty,
Doesn't make any difference.
then that can't be relied upon against the investor.
Exactly. And all the parties to this treaty have agreed that they can't rely upon it against the investor as reducing the protection in the ECT. That's the entire point of the ECT, was to give everyone an absolutely gold-plated guarantee that the investor protection, in order to stimulate the relevant capital flows, which are multilateral and complex, in order to ensure energy security and mitigate sovereign risk to everyone's benefit, including all the transition provisions going through different countries, etc. All of that is just as in ICSID. If you literally pull away the one pillar that the entire construct is resting on, it's totally fatal to the scheme. And that's exactly why Article 16 is there. And so you've got an express treaty provision which precludes any of those arguments adversely affecting an investor. Now, there's a more complicated question about what happens between whether one country A, can complain that countries B and C.
That's a different issue, isn't it?
That's a totally different issue.
One's looking at it in terms of the investor.
Exactly.
That's why I asked the question.
Exactly.
What we're concerned with is a claim by investors against one of the contracting states to the ECT. And your point, I think we're going to get to, is that whatever the European Union may have done amongst its own members, which detracts from this treaty and is therefore less favourable to the investor, the parties to this treaty have agreed that as between themselves and the investor, it will be of no effect.
Exactly. And it's literally the shortest answer to the entire EU problem, which is not only have the contracting parties agreed, Spain's agreed, but so is the EU. And in international law, it's absolutely bound. You don't even need to look at the VCLT, Pacta Sunt Servanda. That's an end of the case. I'm obviously going to deal with the other points as well, because they're almost even worse.
Well,
but
let's do that. Let's have a break, because I'm conscious that we didn't have a break.
I'm most grateful.
No, it's not. No, it says 5-2 there, so if we say 5 minutes, we can.
Cooperative able.
Oh, sorry. Terrible.
I didn't think it's
Just please. Is the court ready?
Always.
Thank you. Court rise if able.
Well, those are the key provisions of the ECT themselves.
Yeah.
Could I just deal very quickly with a few references to the disconnection issue?
Yes.
Because I think the point's good on the face of the treaty anyway, but it is significant that the EU sought to obtain by negotiation what it's now announced it's actually entitled to impose on everyone else, or the EU parties, and the consequences of that on all the investors. So in relation to disconnection, can I just start with the article at the back of volume 8, the very back, tab 147, which is the article I mentioned to the court yesterday. It's by Professor Sarl Dashwood. He's obviously a member of my chambers and has been an expert in a number of these cases. I think even in this case, an EU law expert. But it's the analysis, which is the analysis of Comstroy, which is of interest. And if we look at page 4405, I mean, I would commend this article as a whole to the court, just because it's an impressively careful and arguably even generous reading to the CJEU, notwithstanding some of the striking conclusions reached. At 4405, the intended scope of the international obligations accepted under Article 26 ECT, a lacuna in the Comstroy judgment is the failure to consider the intended scope of the international obligations accepted by the EU and the member state parties to the ECT in assenting to the inclusion of Article 26(2)(c) in the treaty. It is submitted that interpreted in good faith in accordance with the ordinary meaning given to the terms, which is straight from the Article 31 of VCLT. Article 26(2)(c) ECT provides for an arbitration mechanism. It's intended to be available to the investors of any one or contracting parties in disputes with any contracting party hosting their investment, including where the dispute between an investor of an EU member state and another EU member state. That seems abundantly clear from the inclusive language of the provisions of the ECT, in particular Article 26(1), combined with the absence of an express disconnection clause, 54. And combined with the absence of express disconnection clause, extreme care taken to define any exceptions to the availability of the arbitration mechanism, and the fact that in the single case of an agreement given precedence over the ECT treaty, the Svalbard Treaty, which was one I mentioned earlier, this was spelled out in an express decision. There's no such decision for the EU. The internal evidence was that such that contracting parties' intention is reinforced consistently with Article 32 of the VCLT on supplementary means of interpretation by the Travaux, as recalled by various arbitrational tribunals. An attempt by the Commission to have a disconnection clause inserted into the text of the treaty that would have excluded the intra-EU application was rejected. This is a clear indication that the intra-EU application of arbitration mechanism in Article 26 was intended to be among the international obligations undertaken by the EU contracting parties, and I would say the EU itself, just to be absolutely clear, towards each other and third country contracting parties, and that it was insisted upon by the latter. And then he deals with it, it's not really a bundle of bilateral relationships and so forth. So just following that through, it's important for the court to have in mind the decision of the Swiss Supreme Court in relation to this case, which we have in the bundle at volume 6, tab 93.
As far as the Professor Dashwood article is concerned,
Yes.
couldn't pick up anything that it says that you hadn't already said to us. What does it add?
Well, my lord, I was just identifying that he gives specific reference to the care taken with the Svalbard Treaty and footnotes all the relevant references.
Yes.
So just
But you'd already told us all.
I've told you the point
Yes.
already, so I'm not saying
I
it's
suppose it gives us the references if we needed them.
all of the detailed
For
references
example,
to
he
where
refers to several other ICSID arbitrations
Exactly.
where this issue has been traversed.
I mean, actually, while we've got that one out before the court, sorry, I've said that a bit too late.
Still
haven't
on
I?
the article, or
No, not on the article, but in the same bundle, just so the court doesn't
Yeah.
have to do a lot of weightlifting. I could have said that a tiny bit earlier. While we're in it, there's the ILC which is also important. The ILC article Learned Friend took you to yesterday at tab 130, which is, he didn't take you to this bit, and the full bit isn't there. But if we look at 4035 in tab 130,
Disconnection clauses.
disconnection clauses, you'll see there one practice that it may be appropriate to discuss here is the expansion of the so-called disconnection clause in multilateral agreements to which the European community is a party. There are presently at least 17 multilateral treaties having as parties both members and non-members of the European community that contain this clause. Footnote 394. And again, I mean, I haven't actually said this point, but it's made helpfully here. If you look down at the bottom of footnote 394, you can see, for example, the Unidroit Convention on Stolen or Legally Exported Cultural Objects, 1995. So even before the ECT was entered into by the EU has been using express disconnection clauses where necessary.
What does a disconnection clause say?
What a disconnection clause says is Article 26 will not, the provisions for ICSID arbitration will not apply between intra-EU states. It says what Comstroy now says. So they failed to get it in negotiation, and now the CJU has announced by obiter dictum in a non-EU case, Comstroy, that actually they did get it after all. I mean, I realise I've used some critical language of the position that the EU has taken, but I respectfully submit to the court it is not without a proper foundation. So that's that point. And then if we can come back, we can put that bundle away now.
We're going to the Swiss.
We're going to the Swiss one in number 6. Sorry, it's not, the Swiss case is not, it's against Spain, but it's not our award.
Right.
It's the same point, but it's against Spain, but it's not our actual case.
Tab
So it's
90.
it is tab 93.
Yeah.
And I mean, it gives a coruscating criticism again in the context of international courts, normal, gentle treatment. This is a certified copy translation of the award, and the relevant passage the court may wish to note is essentially the analysis of the arguments that proceeds from page 3278 actually all the way to 3286. Where it's paragraph 7.8.4, they dismiss the alleged lack of jurisdiction of the arbitral tribunal. In the relevant parts to look at are the reference in paragraph 7.3 on 3277, just on our disconnection point. So this is the same point being made and noted by the Swiss court, made to the Swiss court, about 6 lines down on the right-hand side, right-hand margin. Respondent insists, does the court have that? Respondent insists that the EC does not.
Sorry, can you say again where it is?
So it's paragraph 7.3,
Yes.
and it's right-hand margin on 3277. The respondent insists
The ECT does not contain any disconnection clause.
any disconnection clause authorising the members of regional organisations such as the EU not to apply, and stresses that the EU had included disconnection clauses on various occasions before the ratification of the ECT, making good the point there. And then there is, we respectfully say, I'm not going to take the court through it, but I would, just because of time, but I would invite the court to consider the powerful reasoning of the Swiss court, essentially from 7.62 onwards.
Well, it's the passage that's sidelined on
7.9 and 3.2.
3281.
Yeah, I mean, actually, there's quite a lot of it's important. I mean, 7.6.3 at the foot of 3278, the beginning of 7.6.2 identifies it, and then actually it's the bottom of 7.6 on 3280, the last few lines there. The assertion of primacy of its law over that resulting from other agreements, about 5 lines up, just above the bottom hole punch, giving its decision the character of a pro domo plea. Consequently, this court will not give particular value to the judgment rendered by the CJEU in Comstroy.
Sorry, I didn't pick that up. Where?
I'm so sorry. 3280, my lord.
Yes.
And it's the top hole punch.
Yep.
And it's actually quite powerfully reasoned. There's a run up to, well, probably to show you exactly which bit is probably more helpful. If you sort of throw a dart at the middle of the top paragraph
On page?
on page 3280, do you see the phrase, it is less so?
When it comes to determining.
Yeah. It's less so when it comes to determining whether the rules adopted by a community of states such as the EU should prevail over those resulting from international multilateral treaties such as the EC, binding that community, its member states and third states. It must be seen that in such a case, the legal problem is not limited to assessing the scope of a foreign law standard, but to examining the legal relationship between the rules anchored in various instruments of an international nature. However, in the presence of a conflict of such rules, it may be that judicial authority established by the said community of states is tempted, as in the Comstroy case, to assert the primacy of its law over that resulting from this other international agreement, thus giving its decision the character of pro domo plea. Consequently, this court will not give particular value to the judgment rendered by the CJEU in the Comstroy case, but will, on the contrary, seek for itself the meaning and scope of Article 26 ECT, and where appropriate, whether EU law can effectively call into question the validity of consent given by the state, using the implementation of arbitration to settle the dispute between the respondent and so forth. And then 7.71, totally conventional approach to treaty interpretation in good faith. We remember, of course, the recital in the preamble that the ECT was negotiated in good faith, compounding the good faith context that would normally apply in any treaty. And then the sidebar bit in 7.7.1, second line of that, interpreting in good faith, the term unconditional means that consent to arbitration is expressed without any reservation and thus knows no limits. Such consent has a general scope, since it refers to the submission of any dispute to arbitration. The expression subject appearing in Article 26, paragraph 3, point A, in initio ECT, certainly indicates there are exceptions to unconditional consent to arbitration, but these are listed exhaustively and concern only the cases referred to in Article 26, 3, B and C ECT, as is apparent from the text of the topical provision. The clear wording of Article 26, 3, point A, ECT thus reveals that the appellant state bound by said treaty has given its unconditional consent to an investor located in another state part of the ECT, like the respondent, to be able to submit to arbitration and so forth. And I won't read all that, but they trace through impeccably what the correct international law analysis is that's required, expressly required by the provisions of the ECT. And they refer, and I can just give the court an indication. The other references to the disconnection point are at 3281 and 3284. 3284 is a few lines down in 7.7.6. And the key bits, that if it's helpful visually, that I've highlighted on 3284 are at the top of 3284, 7.7.6, and then the whole of 7.8.2, the whole of the next page, and half of the top half of 3286. So I mean that it's completely conventional. I would highlight to the court though, the point that I made just before the break, the Article 16 point, is expressly picked up by the Swiss court itself at the foot of 3285. And the court will see on the left-hand margin, just below the bottom hole punch, but there is more. Does the court have that?
Yeah.
3285, left-hand margin, but there is more. So this is in addition to all the normal reasons, which even in the absence of Article 16 would be an answer. On top of everything else, you've got Article 16, which is the ECT contains effectively a specific conflicts rule to regulate the relationship between that treaty and an international agreement earlier or later by two or more contracting parties. Article 16 ECT thus provides that no standard of an international treaty concluded by two or more contracting parties before or after conclusion of the ECT may be interpreted as derogating from the provisions of Part 3 or 5 or from the right to require settlement of the dispute concerning the point in accordance with the ECT where such provisions are more favourable to the investor. This specific conflict rule, which is exactly what we say it is as a matter of international law, my learned friend was pointing to conflict rules that theoretically can apply yesterday. But well, that doesn't happen if the treaty itself has an express conflict rule.
Yeah.
You don't even get close to that. And less still do you get close to an extremely imaginative interpretation of Article 5 as a conflict rule that might potentially apply. So with the greatest possible respect, it's absolutely hopeless.
But it's a point that's sidebarred at the bottom of 3285 and then
Exactly.
at the top of 3286, isn't it?
Precisely. So I think
The effect of it all is Article 16 is if they wanted to have a reservation or a disconnection or however you describe it, they could and should have allowed for it.
Yeah.
In the ECT, and not having done so, the ECT, so far as the investors are concerned, takes precedence over the treaty, the European Union treaties.
I mean, well, the point is that even without Article 16, the treaty's still clear in our favour.
Yeah.
And then Article 16 goes, and by the way, it's a ratchet conflicts rule, because the ratchet's only in favour of the investor.
Yeah.
I mean, that's super important when you're trying to get people to raise billions of pounds to build your green energy infrastructure. And you're saying it'll all be okay. So that's the point on the Swiss one.
Yeah.
And then there is an example of one of the suggestions of the Travaux. I'm not going to take the court to it, but in the Travaux, one of the times when the EC had a crack at getting a disconnection clause in is found in Bundle 7, 105. And maybe it's worth looking at it just to see what we're talking about. Bundle 7, 105, which is the Travaux at 3654. Sorry, wrong tab. Sorry, 1 second. Bundle 7. I've got a mistake in my note. Sorry, apologies. It's Bundle 7. Oh no, I've misread it. 105. Yeah.
Tab 105.
Yeah, tab 105. There we are. It's page 3564.
(3564), isn't it?
Yes, and if the court looks between the two hole punches at 2718, there's a little bit sidebarred as an example of one of the attempts of the EU to get a disconnection clause. And everyone says, it defeats the whole point.
Yeah, well, that provision would effectively say this treaty doesn't have any effect. That's between member states.
For those
if they don't.
Exactly. And the problem is that because everyone's got an interest in the treaty working, because, for example, even the practical things, the transition provisions of energy going through other countries, everyone else said, no, you're not having that. And it was not included. And we respectfully say that's obviously highly significant. It's an absolutely extraordinary move by the CJEU through Constroy to try and get in what the actual parties of the treaty refused. And then say to everyone, all the member states, you're bound by the duty of sincere cooperation. Come along and stand outside and make these declarations.
And everyone's rationalising that a way of doing it is to say, well, this is not a bundle of bilateral obligations.
It isn't. Exactly. Yeah. I mean, and on conventional treaty analysis, the same way that the Supreme Court analysed whether the ICSID Convention is a bundle of in bilateral obligations, said no, it's not. Exactly that approach leads to exactly the same conclusion when you analyse the ECT, and there's no really sensible contention to the contrary. And the only one that's been made is a pretty eccentric one by the CJEU to sidestep Article 357. So it's
on any view, this court can't be bound by the CJEU's analysis of whether it's purely bilateral.
Exactly. It's not even a matter actually properly conferred on the court to decide, actually, on the 72 Act point. But, so it's sort of even worse. So that gets us through disconnection. There are some other points. I'm doing reasonably well, my lords. I'm going to hopefully finish around 2:45, so a bit less than the overrun.
Yeah, okay.
I'm learning friend, but if I can be quicker, I will. But I don't want to be unhelpfully quick because some of these points are quite important. Mm-hmm. So please do slow me down or ask me if there's any concerns. There is an EU competence point, which is another bizarre dimension to the Constroy decision. And that is this. And the only reason I mention it is because my learned friend Mr. Ballock is suggesting that we look at EU law through the international law lens. So if it was a pure question of EU law internal to the EU, obviously the CJEU can say, we're actually all from Mars and everyone has to agree. They can say anything they like. It's self-authenticating and they can say what they like. Everyone has to go along with it. And I accept that. And so did the judge below. It's entitled to the utmost respect for the purposes for which they're authorised to do that. But what's actually asked of this court is to consider EU law as finding expression in international law. And one of the problems, I'm not sure it matters because the arguments are so flawed in any event, but if it does matter, no conventional international law analysis of the structure of the EU treaties would be likely to admit the result achieved in Constroy. And the reason for that is that there are key aspects of both international law and the EU treaties which militate very strongly against such a conclusion. And those are that a treaty entered into by the European Union forms part of EU law, an external treaty, like the ECT, forms part of EU law, and under the treaty, it binds the institutions of the EU as defined in the treaties, which include the court. So even in a sort of basic primer on international law, it would be a little bit surprising if the CJEU was authorised under the EU treaties in any way that we would understand to make a decision flatly contrary to obligations freely undertaken in the ECT.
By the EU.
By the EU. Because the EU's entered into the treaty. The EU treaty architecture says that forms part of EU law.
Yeah.
And that those treaty provisions are binding on the EU. And we get help from that.
Does Constroy deal with that
No,
that
no,
problem at all.
no, it doesn't. I mean, also I worked at the Commission, so it becomes an extraordinary place. I mean, there were neither of them was an EU party, so no one expected it to be decided. There's a powerful criticism in Sir Anne Dashwood's article, which I didn't take you to, the bit of it, of the competence of the court to make that decision at all, because it was not a question referred to the court on the reference procedure in Comstroy. And the genesis of how they actually made the decision requires us to look just briefly at bundle 6, if we may.
Yeah.
So can I just sort of set the scene, although this comes later, if we look at tab 78 in bundle 6. So this is opinion 120, and it's in June 2022, so it's later. But it goes to an anterior point about the making of the treaty. And the point about this is, Belgium is seeking to clarify whether the proposed modernised ECT is compatible with the treaties. And it's a perfectly responsible thing to do. And if we go over to page 2870, you can see what the Kingdom of Belgium's request was to the court, was to say, is to get clarity on Article 26.
Yeah.
And, well, parenthetically, the reason they were asking that is because in Comstroy, there's a suggestion that the EU was not competent to conclude a treaty that breached the principle of primacy of EU law, which is a pretty surprising thing to say, because if it's ultra vires, that's very strange. Anyway, in result of all of this uncertainty, putting it mildly, the Kingdom of Belgium sought an opinion from the court under the specific procedure laid down in the EU treaties for clarification in advance of committing to a treaty of any possible conflict between the treaty provision and EU law. And they specifically look at you can see in the questions asked, the second dash point at the top of the page there, in paragraph 1 on 2870. The agreement does not lay down, second line of that, in Article 26, that agreement halfway across the sentence, that agreement does not lay down a specific express rule or express disconnection clause. So that's what they were trying to clarify. And the short point is that in result, if we go to the back, just taking it speedily, 2877, paragraph 47, the court has basically said that it doesn't know, it's just said just before this, that it doesn't actually know exactly what Article 26 will say in the modernised ECT. That's the foot of the previous page, 2876. So it's not going to actually give a decision on compatibility, even though Belgium was saying, look, in the present draft, 26 remains unchanged. Can you please tell us whether this is compatible with the treaties or not? It's a perfectly sensible request. And the court goes, no, we're not telling you, it's premature. But then it adds, finally it should be added, and you can see 5 lines up from the bottom, it's clear from the judgment of 2nd September 2021, which is the Comstroy decision, Moldova and Comstroy, and in particular from paragraphs 40 to 66, that compliance with the principle of autonomy of EU law, enshrined in Article 344 TFEU, requires Article 26(2)(c) of the ECT to be interpreted as meaning it's not applicable to disputes between member states and investor. So, and again, by the way, no investor invited to make submissions there. So just imagine for a minute that the basic principles of procedural fairness that are enshrined in Article 6 of the European Convention on Human Rights had applied. I mean, they're supposed to apply under the the EU's own internal instruments. But I mean, it's absolutely extraordinary to make repeated decisions. I mean, Constroy was obiter, completely obiter dictum. It's then bedded in by the court in this opinion, having said that they're not able to give an opinion under the relevant procedure, but by the way, we're going to. So that is how the court went about making the decision and disabling itself from deciding that it should not have ex tunc effect. Because once the decision's made, the court can't in subsequent decisions then say this will only have prospective effect and won't affect people who've already got an award, are halfway through an arbitration, invested in good faith, understanding what the ECT meant, or any of those things. So the anterior point that I was going to make about it is, it's plain from this decision that what the machinery is, without me taking you trawl through the treaties, that there's machinery in place within the EU in the case of a prospective treaty about which anyone has any doubts. You can ask the court to give an opinion if there's any problem whatsoever. My lords, that brings me, if I may, I'll come back to 6 in a minute, so we're going to park it somewhere convenient. If I can take you to the new little bundle just quickly. That brings me to Advocate General Wathelet's opinion in Act Mea, which we have in tab 6 of the little bundle, at page AA 166. And it's an eminently sensible, rigorous, and logical analysis of the underlying problem. And the surprise was obviously that the court decided the opposite. If we look at page AA 176, it's under the section 5 analysis, which we see on the heading on the previous page, and subsection A, preliminary observations. And the first part of the preliminary observations looks at the position in relation to various BITs. 38 on page AA 176 says, when asked at the hearing why it did not denounce at least the BITs signed with the member states, which in the present case maintains it did, that those BITs were incompatible with EU law, the Slovak Republic stated its objective was to ensure that its own investors would not be victims of discrimination by comparison with investors of other member states and the member states with which it would no longer have BITs. However, that intention did not prevent it from terminating its BIT with the Italian Republic. At the same time, its own investors continue to benefit from the BITs concluded with member states of the same group, as shown, for example, by the arbitral proceedings identified in that ICSID case. So, firstly, they were trying to say it's ineffective when it's against us, but it's effective when our investors use it, which I think the Advocate General didn't find very attractive. And then, absolutely key point of paragraph 39 onwards, the Commission's argument is also striking. For a very long time, the argument of the EU institutions, including the Commission, was that far from being incompatible with EU law, BITs were instruments necessary to prepare for the accession to the Union of the countries of Central and Eastern Europe. This is the preparatory point that I made yesterday in relation to Micula and what Romania did. The association agreements between the Union and candidate countries also contain provision for the conclusion of BITs between member states and candidate countries. At the hearing, the Commission attempted to explain that change in its position on the incompatibility of BITs with the EU and FEU treaties, maintaining the agreements in question were necessary in order to prepare for the accession of candidate countries. However, if those BITs were justified during the accession period and each party was aware that they would become incompatible with the EU and FEU treaties as soon as the third state concerned had become a member of the Union.
Yeah.
Why did they not provide for termination? So there were no sunset clauses, no provisions. Anyone looking at those BITs, including the one in Micula, had no idea they were at risk from the becoming invalid as soon as that country joined, which is the whole point of them entering into the BIT in the first place, under the association agreement. And then you get the ECT point at paragraph 43, which is the critical point on the treaty with which we're now concerned. Furthermore, at 43, all the member states and the Union have ratified the Energy Charter Treaty. That multilateral treaty on investment in the field of energy operates even between member states, since it was concluded not as an agreement between the Union and its member states of the one part and third countries of the other part, but as an ordinary multilateral treaty in which all the contracting parties participate on an equal footing. In that sense, the material provisions for the protection of investments provided for in that treaty and the ISDS mechanisms also operate between member states. I note that if no EU institution and no member state sought an opinion from the court on the compatibility of that treaty with the EU and FEU treaties, that's because none of them had the slightest suspicion that it might be incompatible. So none of them, nobody, prior to the ECT, even though it was a baby of the EU was the convener for the ECT, nobody used the procedure that I've just shown you in opinion 120 to clarify, challenge, in any way contend that there was any problem whatsoever with the EU and the member states individually entering into the ECT. So that's the relevant background in relation to that specific point. Can I take the court now back, if I may, to the CETA opinion? I know I'm killing this point about 65 times, but I mean, it's already dead in the water on the face of the plain words of the ECT itself.
Article 16.
No, even without Article 16, we say it's dead anyway. Then we say Article 16 is a specific conflicts rule that precludes the very point that's now being taken against us. Then we say that's a fortiori where the EU tried to negotiate the disconnection clause and didn't. Then we say it's further a fortiori, whatever that is in Latin, many times over, when you have the fact that they went into this willingly and with no opinion from the court to the contrary, because absolutely no one thought there was any conflict. And the reason they thought that is absolutely plain in the treaties, in the EU treaties, which is that once the EU agrees to an international treaty, it's binding on its institutions. So it comes below the treaty, the TFEU and TEU provisions themselves. Then you get the international agreements, and all of that is binding on the institutions. And the court has sort of manufactured a way of not being bound by the ECT in circumstances where its own foundational treaties say that it is bound by those treaties.
Right. So where are we going now?
Can I take the court now to, sorry to emphasise that somewhat, but it's pretty striking. It's tab 9, the CETA opinion, and that's, sorry, bundle 6, apologies, the one we kept out, and it's tab 74. So, the short point in relation to the CETA opinion is this is an example of, if we look at the first page, 2757, just at the sort of head note, it's the comprehensive economic and trade agreement with between Canada and the EU and member states. And the Commission was very keen on this, and the EU was keen on it, and it had ISDS provisions. And in this opinion of the court finds it's all absolutely fine. And there is no legitimate functional distinction between this treaty and the ECT. And there are many points that could be made on it, but in the interest of time, I'll only take the court to page 2782 and two other references. At 2782, paragraph 116, and just to reassure the court, these are the references that are on the sheet, the reference sheet I gave for the EU and ECT. Indeed, with respect to international agreements entered into by the Union, jurisdiction of the courts and tribunals specified in Article 19 TEU to interpret and apply those agreements does not take precedence over either the jurisdiction of the courts and tribunals of non-member states with which those agreements were concluded, or that of the international courts or tribunals that are established by such agreements.
So that would seem to be saying that if the treaty in question contains a provision for arbitration by a particular
It's fine.
tribunal, that arbitration by that tribunal takes precedence over
Yes. And then
the
if we
jurisdiction of the EU court.
it's perfectly permissible. So not only is construy extraordinary for a number of reasons I've elaborated on already, but when they're keen on it, they say it's totally fine. And the CETA opinion is a very important decision. And if we look, there are two other references which I've identified in the reference note on the ECT EU issue. They are actually probably the simpler one to go to is actually the 124 and 126. I won't go through them. They consider this applicable law point. And the obvious difference is that in the ECT, and this is one of the premises of the criticism that Sir Alan Dashwood made in the article, the applicable law under the ECT is international law. It's not domestic law or EU law. And that's the same in the case of the CETA tribunal. And if we go forward, actually,
Just in terms of what the court said, it says in 126 that ACMEA is different because the ECT established a tribunal that would be called upon to give rulings on disputes that might concern interpretation or application of EU law.
and that was precisely because, and this is why nobody anticipated ACMEA would extend, although the Commission was keen, because in ACMEA they made the decision on the specific provisions of Article 8 of the BIT, which said it would be determined by domestic law, which included EU law. And the point of distinction here is the applicable law under the ECT is international law. It's got nothing to do with EU law. And that's the same provision as the same distinction that they make in 126, as your Lordship, my Lord, Lord Justice Newey points out. And then, I mean, just for good measure, 2788, paragraph 165. On that subject, it must be recalled that international agreements entered into by the Union must be entirely compatible with the treaties and the constitutional principles stemming from them. And you know, it is that point that is now said to be taken against the ECT by the CJEU in circumstances where the EU's constitutional order and the jurisdiction conferred upon the CJEU by the treaties is subject to international agreements entered into by the EU. So, I mean, if you're going to take the constitutional structure point, it's surprising that the court didn't say we're bound by this treaty and actually address the point head on. And that's missing from the analysis in Comstrike.
You just referred to international law.
Yes.
We had some discussion,
Yes.
Mr. Ballack, about the reference in Article 26 to international law.
Yes.
That didn't seem to provide the answer on the face of it.
Well, my lords, the normal principle under VCLT is the treaty itself will be interpreted in accordance with that international law. And there are a few points on the VCLT that I'd like to take the court to in the few minutes that remain just before lunch, if that would be a convenient thing to do, because I do slightly think that a lot of the answers to this case are just found in the clear words of the two treaties, as supplemented by the approach in the VCLT itself. The VCLT is in bundle 7 at tab 101.
Yeah.
And so if I can just take the court through perhaps sort of pretty much in order, because that's a helpful way to go through. 3405 has Article 5 on it, which is the one my learned friend relies on. And all that says is that the VCLT doesn't interfere with internal rules of interpretation of treaties by regional organisations like the EU. What it does not do is elevate the EU's internal legal order, and I'll show you this in Cavallum after lunch. It does not elevate the EU's internal legal order onto the plane of the international law plane, such as to trump everyone else's international law rights and obligations. It's not that's the tail wagging the dog, with the greatest respect. The 3410, we have the conventional provisions that the court will be very familiar with in Part 3, which is the observance, application and interpretation of treaties. And Article 26 is the Pacta sunt servanda provision, in breach of which the EU is now acting in every single case where it's impeding the objects of the ECT and the arbitration provisions. Requires every treaty, it says every treaty enforced and binding on the parties must be formed by them in good faith. And I regret to say it's our submission that there is a striking absence of good faith in the position adopted by the CJEU and the Commission in relation to these provisions of the ECT. Article 30, court will be very familiar with, application of successive treaties, same subject matter, and these are the provisions on alterations. And obviously they're completely excluded by Article 16 anyway, but if Article 16 was not there, and the separate provision for amendments in the ECT were not there, they would have to try and find an avenue through Article 30 to get their disapplication argument or something of that sort up and running. And Article 30.3, when all the parties to an earlier treaty are parties also to a later treaty, but the earlier treaty is not terminated or suspended, the earlier treaty applies only to the extent that its provisions are compatible with those of the later treaty. When the parties to the later treaties do not include all parties to the earlier one, etc., as between parties to both treaties, the same rule applies. You'll note too.
So just pausing there, why doesn't that apply here?
Well, because it's precluded by the structure of the VCLT and the express provisions of the ECT. So what I'm showing you is that had they not had an express conflicts rule in the ECT, they would have been able to try, I'm trying to be as fair as possible, they would have been able to try and get it within these provisions.
So just to talk it through for a moment.
Yes.
So if we focus on the TFEU for a moment, since that's obviously subsequent, the parties to the TFEU do not include all the parties to the ECT.
Yes.
But as between states that are parties to both the TFEU and the ECT, which is the member states,
Yes.
the same rule applies as in 3, and that says that the earlier treaty applies only to the extent that its provisions are compatible with those of the later treaty.
Except that the anterior objection, I probably shouldn't spend as much time on this as I have, but the anterior objection to the applicability of Article 30 is that it's not the same subject matter. So this only applies, as you'll see from the heading in Article 30, it only applies where the successive treaties relate to the same subject matter. And it's a successive treaty. And
Your point there is the ECT specifically relates to energy,
exactly.
and the treaty with which it's said to conflict is
The
the
general treaty for the
TFEU.
EU. Yeah. And there's also a huge problem with Malone and Friends' lex posterior argument.
Sorry. Just before you do that, is there any authority as to the significance of the words subject matter? I mean,
Well, it was
if you
conceded.
find 2 treaties covering the same ground, do they deal with the same subject matter?
Well, my lord, it was conceded below Mr. Justice Fraser, and I don't believe it's disagreed now, that they're not the same subject matter. There is a conflict
There's nothing in the TFEU
for investor protection.
or the TEU that deals with energy, is there?
Well, there are some energy provisions.
In the
within
same
the-
way as this treaty?
No, not the same overall structure.
No, that's
So-
isn't that the point?
Yeah, and that's why Malone and Friend quite rightly conceded below that it wasn't the same subject matter. And that's quite important. But the application of the VCLT is always subject to the express words of the underlying treaty anyway.
Well,
So-
I mean, supposing that they did cover the same subject matter, I don't quite see
Yes.
how that could be true, because there would be, so to speak, an implied repeal of the bit of the first
Yes,
treaty.
so that's Malone and Friend's lex posterior point, which just ignore the subject matter. There's a clear answer to that too, which is what's actually said is by the reenactment of the primacy point of the underlying articles on primacy after the treaty, magically the entire basis of Article 26, the underpinning investor protection, disappears. Because primacy's been there since Costa and ENEL. So it's a completely hopeless argument without any reality to it, that this is a successive treaty relating to the same subject matter, which should override the express conflicts clause in Article 16. But I'm just trying to be scrupulously fair by showing the court that does exist in the VCLT in Article 30. And then you've got the general rule of interpretation in Article 31 over the page at 3411, which the court will be very familiar with. And again, that reinforces the good faith element to which I've already referred. So we've now got that in 3 places. We've got the preamble to the ECT saying it was negotiated in good faith, which is important. We've got Article 26, Pacta sunt servanda, and then we've got the interpretation of it in good faith. And then we've got inapplicable provisions in relation to the amendment and modification of treaties in Article 39 and 40. 39 is agreement between the parties, and the rules laid down in Part 2 apply to such agreement except insofar as the treaty may otherwise provide. So you've got the importance of the underlying treaty provisions, express treaty provisions there. And Article 40, amendment of multilateral treaties, which is the ECT, unless the treaty otherwise provides, the amendment of multilateral treaties shall be governed by the following paragraphs. So well, this is actually the directly relevant amendment provision. Any proposal to amend shall, as between all parties, must be notified, etc. And then 41, as these two articles together are the relevant amendment provisions. 41 on 3413 is agreements to modify multilateral treaties between certain members only. And that's only allowed under the VCLT if the possibility is provided for by the treaty, and in our case it's expressly excluded, so fatal, or the modification in question is not prohibited by the treaty, which it is by Article 16, and doesn't affect the enjoyment of other parties, which we say it does, and doesn't relate to a provision, derogation of which is incompatible with the effective execution of the object and purpose of the treaty, which is also fatal. So, even if you got to this, the Article 41 is the actual one they would have to use, and they can't satisfy anything in it.
The point here is that insofar as the VCLT deals with, as it were, the Article 16 point at all, because Article 16 is very
preclusive.
clear,
Exactly.
then it's really, it has to fall within Article 41, which it doesn't.
Yeah, but you can't even, you don't even get really to Article 41 anyway, but I'm just trying to be super fair and show the court.
There's nothing in the VCLT which in terms deals with an Article 16 situation.
No.
And you said, as it were, in advance.
Exactly.
Even if we enter into a subsequent agreement,
Yes.
it will be of no, its terms will be of no effect if they adversely affect.
Exactly.
the
And the consent of the contracting parties and the obligations of the tribunal are to apply first and foremost to the DECT and its express provisions.
Is there learning on how Articles 30 and 41 fit together?
Well, my lord, there may be, but because it wasn't said to be the same subject matter, and that provision, we haven't provided that. If it became important, I'm sure we could provide, but respectfully say no. And then there's one final point, if I can do it, like 2 minutes before lunch.
Yeah.
I've noticed the time, unusually. Article 46 is on page 3414.
Yeah.
It's actually really important because it's the well-known provision debarring contracting parties from saying only joking after you've signed up. Because actually it turns out we couldn't do that. And it provides in 46.1 a state may not invoke the fact that its consent to be bound by a treaty has been expressed in violation of a provision of its internal law. That's exactly what the EU is trying to do regarding competence to conclude treaties, and where it talks about its competence to conclude a treaty having the effect for which we contend, that is exactly the wording it's using. Unless that violation was manifest, see A.G. Watherley saying absolutely no one had any idea there was a problem at all. So they, on the facts, they can't get anywhere close to that, particularly if that was the view of one of the court's own advocates general. And two, second limb, unless it was violation was manifest, which it wasn't, and concerned a rule of its internal law of fundamental importance. Well, it certainly was not manifest, and there's an argument between the parties as to whether it's a rule of fundamental importance in that sense. But it can't pass the manifest test. And then it too provides a violation is manifest, it will be objectively evident to any state conducting itself in the matter in accordance with normal practice and in good faith. I mean, that does not survive the facts. It doesn't survive the Watherley point, nor does it survive the express attempt to introduce a disconnection clause. And there we are at 2 minutes past.
Right.
If that's convenient moment.
Please.
Court rise if able.